I'm Judge Leslie Kim Smith. Good morning. We are now live streaming on YouTube and on the record. You can call the first case.
All right. Calling case number 250103114 NF Regina Ayubini versus Citizens United Reciprocal Exchange Company.
Good morning, Your Honor. James Flynn on behalf of Defendant Cure.
All right. And Mr. Flynn, this is your motion to compel depositions and IME?
That is correct.
All right. I didn't get a response.
I have not received a response either, Your Honor.
All right. I'm going to grant your motion. So plaintiff's deposition, you're requesting plaintiff's deposition in 14 days. That seems pretty short. Did you want to?
It is, that is what was written. I think I'd like to modify that to 30, though.
Okay. So your motion is granted. Plaintiff is to appear for a deposition within 30 days. And then it's my understanding that you already have an IME that is scheduled for January the 22nd. Is that still on?
That is correct. And we'd like
Correct.
that day to be compelled.
All right. And attend IME for January 22nd, 2026. You may submit an order.
Thank you, Your Honor.
You're welcome.
Calling case number 25007-917 NI Aaron Ray Mitchell versus Progressive Michigan Insurance Company et al.
Samantha Lytle on behalf of Defendant Progressive.
All right. And this is your motion to move to track 2?
Yes, Your Honor.
And there was no response filed?
I do not see that one was received.
All right, I've had an opportunity to view your motion. Your motion is granted. I'll move you to track 2. On track 2, the witness list is going to be due February the 3rd. Discovery cutoff is April the 7th, and case evaluation month will move until June 2026. Just make sure your order includes all of the scheduling dates on track 2.
Thank you, Your Honor.
You're welcome.
Calling case number 25002-103 NI Thomas Brockway versus Karar Faisal.
Good morning, Your Honor. Carrie Rhodes on behalf of Defendant Kazel and K&Z Logistics.
Good morning, Your Honor. Attorney Kristen Trogan on behalf of Plaintiff Thomas Brockway.
And Ms. Trogan, was there an objection to defendant's request to move to track 3?
No, we're not opposing defendant's motion, Your Honor. We leave it to your discretion. We do still need to get the defendant's deposition, so we just ask defense counsel to send us some dates.
All right, Ms. Rhodes, that's good for you?
It's great for me, Your Honor.
All right, I've had an opportunity to read your motion. I'm going to grant your motion. I'm going to move you to track 3. On track 3, the witness list is due January the 20th. Discovery will continue to case evaluation, and case evaluation month will move to May of 2026. Just make sure you get your discovery in within that time period, because I'm not likely to allow for any further adjournment since you'll be on track 2. I'm sorry, track 3.
Thank you, Your Honor. I'll
All
prepare
right,
the
have
order.
a good day.
Thank you
you.
too.
Calling case number 25003-581 NF Danielle Frick versus Auto Owners Insurance Company.
Good
Morning.
morning, Your Honor. Courtney Fall on behalf of Defendant Auto Owners.
Morning, Michael Bashir on behalf of plaintiff.
All right, was there an objection to defendant auto owner's motion to adjourn to track 3?
No.
All right, I've had an opportunity to view your motion. I'm going to grant your motion. I'm going to move you to track 3. On track 3, the witness list is going to be due February the 16th. Discovery cutoff is April the 20th, and case evaluation month will move until June 2026. Make sure you get all of your discovery done by then, because I'm not likely to allow for any further adjournments. All right.
We'll do so, Your Honor. I'll submit an order. Thank you. Have a nice weekend.
You too.
Calling case number 24017-439 NI Stephanie Rose versus John Doe et al.
Good morning, Your Honor. Tommy Andriopoulos on behalf of the plaintiff.
Good morning, Judge Chad Dushinsky on behalf of Defendant PV Holding.
All right, and this is your motion to compel a non-party to comply with discovery subpoenas. Any objections?
I've got no objections, Your Honor.
Okay, all right, so I'm going to grant your motion. How far out do you want to have the show cause hearing scheduled?
How about 21 days if the court's available?
21 days. That would be February the 6th, 2026. And do you want a 9:30 or 10:30 time?
Same time works for
10:30.
defense, Your Honor.
All right. So first step, rehab, General Motors, employment. Is it Mid-Ortho Surgical Center and Providence Hospital will have 14 days in which to comply with your discovery subpoena or appear for a show cause hearing for February 6th at 10:30 via Zoom. Just make sure your order includes the contact information and join Zoom.
Will do. Thanks,
All right.
Judge.
Have a good day.
You too.
Thank you.
Calling case number 25002325 E&I Ishmael R. Masari versus Cure et al.
Good morning, Judge. Frank Partapil on behalf of the plaintiff.
And this is your motion to compel the deposition of defendant,
Sultan.
or the owner.
He's a defendant as well, Your Honor.
Oh, okay. All right. I didn't get a response from the defendant.
I didn't get a response as well.
All right, I'm going to grant your motion. In terms of his deposition,
It's presently set for January 29th, 26. My concern is that the case evaluation date and the cutoff date is 2/9/26. So I want to make sure I get this deposition, not only with reference to the case against Sultan, but Cure Insurance. They've taken a statement from him, and they're going to use that in their case in chief. I'm going to take his deposition in order to combat that.
all right, so your motion is granted. The owner and defendant is to appear for a deposition January 29th, 2026,
2 p.m.
2 p.m. All right, included in your order.
Thank you.
You're welcome.
Bye.
Bye-bye.
Calling case number 25002-734 E&I Nicole Ann Sladage as next friend versus Charter Township of Brownstown.
Good
Good
morning.
morning, Your Honor.
Good morning, Your
Charles
Honor.
Lovell on behalf of Charter Township of Brownstown.
Ali Ibrahim on behalf of the plaintiff.
All right, this is defendant's motion to adjourn scheduling order to track 3. Plaintiff concurs.
That is correct, Your Honor.
What are you going to do with the facilitation? Are you trying to facilitate before case evaluation?
We have a facilitation on the docket right now for the 27th, so in a couple weeks. Mr. Ibrahim and I, we've been litigating this case very thoroughly. The liability issues are there. There's a minor involved who's had some significant injuries. He has a neuropsychological follow-up this month, but we are trying to resolve the case, and we thought that an earlier facilitation may be able to get us there. But we still, if it is unsuccessful, we still want to be able to have the time to get all our discovery in place.
Okay, all right. I've had an opportunity to read your motion. Plaintiff has concurred. I'm going to grant your motion. I'm moving you to track 3. On track 3, the witness list is going to be due January 29th. Discovery cutoff is April the 2nd, and case evaluation month will move until June 2026. But make sure that you get all of your discovery requests done before then, because I'm not going to be able to adjourn you out any further.
Understood. Thank you, Your Honor. Have a good weekend.
Thank you, Your Honor.
You
Have a
too.
good week.
Calling case number 25002-284 E&I Ahmad Hindi versus Rian Shadet.
Good morning.
Good morning, Your Honor. Kevin Bacon on behalf of the defendant, State Farm.
Anybody else here? No?
I don't see any.
I did get a response from the intervening plaintiff, Pioneer. Doesn't object to your motion. Did plaintiff file a response that you're aware of?
No, not that I'm aware of, and the one that would be the most interested in filing a response would be Progressive, because this is a
But they're
coverage
out of-
priority dispute issue. So
They're out of the case, so I don't know that they would care one way or another whether or not this case is stayed. I was more concerned about the plaintiff, and it doesn't appear as though plaintiff filed a response. So do you have any idea in terms of when you'll hear from the Court of Appeals as to whether or not they're going to accept your application for leave?
I'm not aware, and to be honest, Your Honor, I'm not handling the Court of Appeals matter. That has been referred to another attorney. But from what I can tell, the app was filed on November 17th, and a motion to extend time to file a reply was just filed on January 5th. So
Okay.
it looks like they're looking for additional time in the Court of Appeals. So
All right, so what I'm going to do is I'm going to grant your motion. I'm going to place this case in stay. When you submit the order, can the order also include that at some point in time, if you want to lift the stay, it has to be done by either a stipulated order or you have to file a motion?
we'll put in the order. Yep.
Fantastic. Anything else?
That's all I have, Your Honor. Thank you.
All right, have a good day.
You do the same.
Thank you.
Bye.
Calling case number 25006-928-CZ, American Express National Bank versus Neil McConnell.
Your Honor, Michelle Bourne Fisher on behalf of American Express.
All right, and this is your motion for entry of default judgment?
That's correct.
All right, I've had an opportunity to view your motion. Is there anything you'd like to state for the record?
I don't believe so. I believe that our motion covered it.
All right, may the record reflect, I've had an opportunity to view the motion. This matter was filed before the court on May the 9th, 2025. There was proof of service. The defendant failed to file an answer to the complaint. As a result, a default was entered on October the 6th, 2025. Since that time, the defendant has failed to file an answer to the complaint, appear today, or file a response to the plaintiff's motion for default judgment. The court is going to grant your motion and enter a default judgment in the amount of $25,299.42. If you'll submit an order.
Yes, we will. Thank you so much.
You're welcome.
Calling case number 24009-195 NF Weldon Thompson Jr. versus Mimic Insurance Company.
Morning.
Good morning, Rochelle Kanja
Good
on
morning. Sorry.
on behalf of defendant Mimic.
Good morning, Your Honor. Brett Altman on behalf of plaintiff Weldon Thompson.
All right, I've had an opportunity to read plaintiff's motion. This is plaintiff's motion, correct?
Yes, Your Honor.
All right. You know what? I'm gonna adjourn this matter over. I did notice that I've got a settlement conference with you for next week for January 22nd. But I'm going to give you a different time. If you can pull out your calendars and let me know if you're available to return. On February the 4th, which is a Wednesday at 10 o'clock.
Give me 1 second. I actually have 2 trial depths going around that time. If we can,
No problem. What about February the 5th? February 5th at 10 o'clock.
I have an in-person in front of Snow,
What time is that?
10 a.m.
Oh, 10 a.m. What about 12:30 on the same day on February 5th?
I can make that work.
Mr. Altman,
Works
is
for
that
me,
good?
Your Honor. Thank you.
Okay, so this motion is going to be adjourned to February the 5th, 2026 at 12:30 via Zoom. I'm also going to schedule a settlement conference for the same date and time. Your clients don't have to appear via Zoom, but they need to be available by phone. Okay, so renotice your motion for that date.
And just to be clear, settlement conference upcoming is going to be moved.
Yes, the settlement conference scheduled for January 22nd is going to be adjourned to the February the 5th at 12 noon. So I'll take care of the settlement conference as well as the motion if I need to.
Okay, thank you.
Okay.
Sounds good.
All right, have a good day.
You too.
Calling case number 24017-227 NI Jesse Gonzalez et al. Versus Ronald Martin Williams et al.
Good morning, Your Honor. Chase Bickett for defendant Ronald Williams.
Is it someone here for plaintiff?
I have not seen
No.
anybody, and I don't see a response was filed by anybody else.
Plaintiff filed a response indicating that plaintiff Gonzalez did appear for the IME for January the 6th. Did that happen?
Yeah, that was in response to my motion to compel attendance at the IME, and he
Right.
did it. He did attend.
So are we going to cancel that motion then?
Yeah, I believe we canceled that motion. This motion is the motion to adjourn.
Okay, all right. I just want to make sure that we've got it. Okay.
Yeah, that's
We
taken
just-
care of.
We just have your third motion to adjourn dates and you want to adjourn them 60 days. Now you're already on track 3.
Correct, Judge.
Yeah.
And I can elaborate a little bit if the court has time.
I don't think you need to elaborate. I understand. I did
Okay.
read your motion. So it's my understanding that one of the plaintiffs appeared for a deposition. However, they were in a restaurant or something like that, and you ended up having to have it rescheduled for January the 8th. Did the January 8th deposition go forward?
Yeah, both depositions went forward.
Good.
The one was for Jesse Gonzalez was 2 days ago.
Okay. right.
That took place, and he basically couldn't tell us anywhere he's ever been treated, but he did have a neck surgery and another accident after this one. So we're
You
kind of
need
having to
to look
work backwards to figure
Yep.
out where he treated.
Okay.
The other deposition, Maribel Sanchez did
I
get
got it.
completed.
Too much information.
All right, I'll
All
stop.
right. I'm gonna grant your motion, so I'm going to, even though you say it's track 3 again, you're already on track 3. So witness list is gonna be due March 5th, 2026. Discovery cutoff, I'm gonna give you, even though you asked for March the 5th, I'm gonna give you until the end of March. Let me look at my calendar to see what date that is. I'm gonna give you until March 31st, 2026 for discovery. And then case eval, instead of moving it to May, I'm going to move it till April of 2026. So witness list due March 5th, discovery cutoff March 31st, and case evaluation April of 2026. Is that
Thank you,
good?
Judge. Yeah, we'll submit the order today. Thank you.
Fantastic. Have a good weekend.
You too. Appreciate it.
Thank you.
Calling case number 24017229 NO Zanat Ziader versus Burlington Store Inc. et al.
Good morning, Your Honor. Al Bauer on behalf of the defendants.
All right. And this is your motion to dismiss?
Yeah, Your Honor, we got an email from the plaintiff's counsel this morning. They're gonna, they've agreed to voluntarily dismiss with prejudice, so we'll be submitting a stip in order.
Fantastic. All right. Thank you for letting me know.
Thank you, Your Honor.
All right. Have a good day.
You too.
Calling case number 250164443 NF Antonio Truitt versus Cure Auto Insurance.
Counsel, will you place your appearances on the record?
Good morning, Your Honor. Patrick Rooney on behalf of the plaintiff, Antonio Truitt.
Good morning, Your Honor. Michelle Andrus appearing on behalf of defendant Cure.
All right. And this is Kira's motion to set aside default judgment.
That's right, Judge. This is our motion to set aside the default in this matter that was entered by the court on December 5th of 2025. The lawsuit was served on Cure on October 23rd of 2025, making an answer due on November 20th. So the default was entered just 2 weeks after the suit was due. I was off on maternity leave during the time that this matter came to my office. There was another attorney, her name is Taylor Berry. She was handling my files. When the suit came in, my assistant was not copied on the referral, and due to the procedural irregularity, it was not answered on time. I did reach out to plaintiff's counsel regarding a voluntary set aside of the default, and he wanted a monetary sanction due to the late answer. There's no harm to the plaintiff for setting aside the default. This suit was filed just over 2 months ago. So we're asking the court to set aside the default entered in this matter.
All right, Mr. Rooney.
Yes, Your Honor. I have filed a response to the motion, and I indicated therein that case law sets forth that attorney error is not a good cause for setting aside a default. In this particular situation, what I heard today was the name of an attorney who apparently had Ms. Andrus's file or Mrs. Andrus's files while she was on maternity leave. And we don't have an affidavit from that attorney. Rather, we have an affidavit from a claims adjuster who states at paragraph 6 the attorney handling Ms. Endress' files was unaware of the proper protocol for referral of files. I don't even understand what that means, Your Honor. They have a case that comes in. There's an answer that's due. There's a letter indicating that they have 28 days within which to answer, or they will be subject to a default. I waited. No answer was forthcoming. This was not a rush to the courthouse where the day after the answer was due, a default was entered. Rather, after 2 weeks, I entered a default. And I have also indicated that there are 2 steps to setting aside a default. The first, demonstration that there was a proper reason for the complaint not to be answered, not just that an attorney didn't do their job. The second basis for setting aside a default is that there is a meritorious defense. So we have an affidavit from this claims adjuster, Colton Smith, who states that Mr. Truitt is not entitled to no-fault PIP medical benefits. That's what the affidavit states. And in response to that, I filed the declaration sheet for Mr. Truitt as an exhibit indicating that, in fact, he was entitled to PIP medical coverage. He was entitled to that up to $250,000, Your Honor. And Ms. Endress has had my response since January 12th. There's been no countervailing exhibit filed by her indicating that there's a basis for saying that the declarations page that was provided by the defendant is somehow wrong. So the meritorious defense that he's not entitled to PIP benefits hasn't even been addressed since I filed what is their declarations page for their policy. So here, as I set forth in response to the motion, it seems as if Ms. Endress feels she's entitled to a default being set aside. So the court rule provides that in order to set aside a default, the court may award reasonable attorney fees to the attorney who entered the default. I indicated to her before that I would be willing to set aside the default if she paid that reasonable attorney fee, because it does take time, Your Honor, to properly track a file, as was not done by Ms. Endress's office, and to take the necessary steps in order to enter a default. Now, I've been compelled by Ms. Endress to spend about 3 hours responding to the motion that she filed, when in fact she is in the wrong, and she knows it. Her firm is in the wrong. And to me, it's just hubris that she would go forward with this motion. And under the circumstances, I don't think that they're entitled to the relief that's requested. I think it's a misuse of judicial resources for her to have come before this court and say, oh, we're entitled to have our default set aside, when in fact, she's not demonstrated a reasonable excuse, nor has she demonstrated that, in fact, there is a meritorious defense to this case. So at this point in time, Your Honor, I would ask that you don't set aside the default. And as I set forth in my response to the motion, what that means is we proceed forward with Mr. Truitt being entitled to the PIP benefits that are set forth on his declarations page, and they still have the opportunity to contest damages, meaning they have an opportunity to contest whether or not the medical expenses that were incurred are reasonable, whether or not his wage loss claim that's incurred is reasonable, so that they're not harmed as a result of the default not being set aside, in the sense that they cannot defend the case. Rather, they cannot contest whether or not Mr. Truitt in fact had the PIP benefits, medical benefits, that are set forth on his declarations page, Your Honor. And I think that under the circumstances, it's appropriate to not set aside the default.
All right.
That's what I would say.
Ms. Endress, is there a reply?
Judge, I would just like to state that we do have correspondence from Blue Cross indicating that the Blue Cross plan meets the requirements to be considered qualified medical coverage, which would offset plaintiff's entitlement to PIP medical under the policy. I apologize that this was not filed, and I acknowledge that I received plaintiff's response to our motion on Tuesday, and I could submit this as a supplemental exhibit if the court wishes, but there is meritorious defense for setting aside the default. And as to the good cause element, Judge, I do leave that to your discretion. There was a procedural irregularity that led to this default, but again, there was no prejudice to plaintiff in this case. There's just 2 weeks transpired from the date the answer was due and the date that the default was filed.
If I may, Your Honor.
Nope, I've heard enough. Thank you. May the record reflect, I've had an opportunity to listen to oral argument. This is Defendant Cure's motion to set aside default judgment. Defendant Cure has argued that the named attorney that would be handling the case was on maternity leave. No dispute about that, but that there was some administrative issue where the complaint was never sent to an attorney, or maybe it was. It's not clear. There seems to be a conflict in terms of whether or not there was a attorney acting on Ms. Indra's behalf, or was it just a administrative staff. Be that as it may, a answer to the complaint was due October the 31st. A short time thereafter, on December the 5th, 2025, plaintiff filed, the default was entered against the defendant. Shortly thereafter, defendant did file this motion to set aside default judgment, arguing that because of a clerical error, they didn't file an answer to the complaint, and that they have a meritorious defense in that the plaintiff isn't entitled to PIP benefits. In response, plaintiff argues that an error on the part of the attorney is not good cause to set aside default judgment, further arguing that defendant has failed to show a meritorious defense, and attached to the response was the declaration sheet that showed that plaintiff was entitled to PIP benefits up to $250,000. After listening to oral argument, the court finds that I'm going to grant the motion. I think there is a good cause for granting the motion to set aside default judgment. It seems to me that there was some issue in terms of administration, that it should have been sent to an attorney, but it was not. In terms of meritorious defense, Ms. Indris could have done better in terms of the affidavit. The affidavit didn't mention that the plaintiff had opted out. It was a somewhat vague affidavit. Could have done better, but the court will grant your motion to set aside default judgment, especially in light of the fact that the motion to set aside default judgment was filed shortly after the default was entered. Now, as Mr. Rooney indicated, the court rules indicate that if the court is going to set aside default judgment, then the court may award the non-moving party attorney fees and costs. And I think that that is appropriate in this case. So Mr. Rooney has indicated that he has spent at least 3 hours in response to this motion. So I'm going to grant plaintiff attorney fees and costs in the amount of $2,000.
Thank you, Your Honor.
All right, and that is to be paid within 30 days.
Thank you, Your Honor.
All right, anything else? Oh,
No.
with regards to your answer to the complaint is to be filed within 14 days.
14 days. Thank you.
All right, matters adjourned.
Hi, case number 25011-828 NI Zamora Guadalupe, personal representative of the estate of Gerardo Zamora, deceased, versus Smyrna Reed Mixed Concrete LLC et al.
Good morning. Can you place your appearances on the record starting in plaintiff's counsel?
Good morning, Your Honor, and good morning, Mr. Boyles. This is Samuel Peach with Venn Johnson Law in Detroit, appearing on behalf of the plaintiff.
All right, good morning.
Good morning, Your Honor. This is Peter Boyles. I'm appearing for the defendants in this case.
All right, good morning. All right, Mr. Peach, this is your 2 motions.
Yes, Your Honor. And once again, if it pleases the court, the defendant has filed 2 notices of non-party fault in this case. By way of background, Mr. Zamora was killed on a job site last summer when a cement mixer owned and operated by the defendants backed up over him and killed him. Mr. Zamora was an employee of Creative Cement Incorporated. The general contractor on the job was MHT Construction, and the cement mixer was owned by Mr. Boyle's client, Smyrna. The first non-party at fault notice that Mr. Boyles has filed is with respect to Mr. Zamora's employer, Creative Cement. And we are asking with due respect that the court strike that notice and prohibit any advancing of that theory subsequently for this reason. Mr. Zamora was an employee of Creative Cement. His legal relationship with Creative Cement has no tort basis. There is no tort obligation of the employer to do anything with respect to their employees. Workers' comp, of course, is a matrix that exists in a sort of strict liability where if an employee is injured, the employer is liable irrespective of the conventional duty, breach of duty, proximate cause system. And so with all due respect, we contend that if the employer didn't owe any duty to Mr. Zamora, the defendant in this case can't create or assert that such a duty existed. And therefore, the notion that the employer should somehow be held liable in this case for any damages to Mr. Zamora is without legal foundation. With respect to the general contractor, MHT, I remind the court again respectfully that the common work area doctrine has been clearly and very emphatically enunciated by our Supreme Court as of 2010. The seminal case in common work doctrine matters is the Alderman versus JC Development case that I assume we're all familiar with, but it can be found at 488 Mich 873. And in that case, the Michigan Supreme Court made it abundantly clear that a general contractor only owes a duty to subcontractors under a very specifically defined set of criteria. And those criteria tend to, or don't tend to, but those criteria are defined by the court as requiring some sort of ongoing peril that the general contractor ignored, such as in the Alderman case, it was an overhead wire that had been rigged during the construction process. That was an ongoing peril to everyone. That creates an exception. But again, with all due respect, I submit that there is no exception to the common work area doctrine for a single negligent act, such as running over someone where you shouldn't have been there. And because of that, I ask the court to apply the common work area doctrine to find that there was no duty of the general contractor toward Zamora in this case with respect to the claims being made by the defendant. And I similarly ask the court to strike the non-party at fault notice and to prevent any such implications during the development of the case. Thank you.
All right, thank you. Ms. Boyce, your response?
Yes, Your Honor. I provided my response, obviously in writing, but I just want to touch on a few things. And the governing court rule for notices of non-party fault is quite specific. And our notices of non-party fault comply on point with the court rule. We gave the non-parties names in each on each occasion. We gave the last known address and we gave a brief statement of the basis. Okay. Also, our notices of non-party fault serve the purpose of the court rule and of the statute governing this, and that is Mr. Peach could amend the complaint to add counts against both of these, and he would have the opportunity to do that. Now, I think a way to look at this, Your Honor, is if the statute of limitations had run against the general contractor in this case after the filing of the complaint, and then I filed the notice of non-party fault under the statute governing notices of non-party fault, Mr. Peach would have an opportunity to bring in the general contractor, even though the statute of limitations had run. And I think the standard to be applied would be, does our notice of non-party allow him to do that? I think it absolutely does, because it complies with the court rule. The second thing is, we have taken literally no discovery in this case. We have not gotten the OSHA report. We have not received the City of Detroit investigative report. This lawsuit was filed within 30 days of the incident. So we don't know what the fault is of these non-parties. There may be not, but that's my burden of proof at trial. And if I don't sustain that burden of proof, then the jury isn't going to allocate fault. Finally, the statute does say you can bring in parties that may be at fault, whether or not they could be brought into the case or not. Okay, meaning employers. Finally, Mr. Peach has, cited a bunch of law that was not in his original brief whatsoever, and he's asking us to do an analysis of general contractor liability and the exceptions there too. This is not the time to do that. The time to do that is when we're getting ready for trial. And if I haven't sustained my burden of proof, then I suppose he files what would be tantamount to a motion for summary disposition based on my inability to be able to prove my case against MHT and Creative Cement. But this is premature. It's premature. And then one thing that he did leave out, and he is asking also in his motion that if you were to strike my notices of non-party fault, then I would be completely prevented from raising the potential fault or contribution to the cause of the accident by Creative and MHT. And he's wrong on that. The case law that I cite in my brief says, proximate cause is an element of plaintiff's case. And I can argue various proximate causes that may chip away at that. So, number one, I don't believe our notices of non-party fault should not be stricken. We've complied with the court rule. They're timely. They serve the purpose. If you do strike them, I can still argue that those two entities were proximate causes of the accident. Finally, we've taken no discovery on these issues where I can flesh this out.
All right.
Thank you, Your Honor. I appreciate your patience with me.
No problem. Mr. Peach, anything else you'd like to state?
Yes, if I may, let me just start with the last thing. The fact that discovery is in its infant stages isn't a matter of lack of diligence. In fact, I've peppered the defendant with discovery, and we've conducted an extensive investigation of the vehicle and so forth. So I think both Mr. Boyles and I have been diligent. I don't think he meant to imply otherwise. Second of the 3 points is that the notion of proximate cause, I still believe, depends upon the fundamental premise of there being a duty. And so if there's no duty of either of these two parties, the argument proximate cause would be misplaced. And finally, I think Mr. Boyles may have gone a bit too far by stating that I could add Creative Cement, the employer, to the complaint, because of course I can't. There's an exclusive remedy issue there. So with that detail, I'll rest my comments. Thank you.
Okay, so you're saying that you couldn't, if the court denies your motions to strike as to Creative Concrete Inc., you wouldn't be able to bring them in because there is a workers' comp issue in this case?
Exactly right. Yeah, there'd be an exclusive remedy bar for me suing the employer because he worked for Creative Cement. So the first thing Mr. Boyles and I would hear after I filed that motion to add the defendant would be a motion to strike on the exclusive remedy provision.
All right. Mr. Boyles, did you want to comment on that?
Well, an employee can sue an employer if he can prove intentional actions by the employer. Intentional actions being the employer knew an accident could happen under the circumstances and failed to do anything, like this willful and wanton almost disregard. So there is one theory under which an employee can sue an employer, and that's intentional act by the employer.
Okay, thank you.
Now, again, we don't know if that's, I'll shut up.
I know, because discovery is ongoing. I understand. You know what, what I'd like to do is take this matter under advisement. If you happen to have your calendars, I'm going to give you a return date.
Plaintiff's ready, Your Honor.
Okay. Gentlemen, if you can check your calendars for February the 5th, which is a Thursday at 10:30, and let me know if you're available to return for the court to render a decision on both of plaintiff's motions.
Your Honor, I am in depositions at that time. I apologize.
If I made it at 12:30, would that be better, or that day is not good for you?
I would hope by 12:30, but I can't guarantee it. The attorney on this is kind of long-winded.
All right, let me give you another date.
Thank you.
Let me ask you this, for February the 5th at 8:30 in the morning, is that too early?
No, the DEP starts at 9. I could certainly do it at
Mr. Peach,
8:30.
would 8:30 be okay for you for February the 5th? And if it's not, just let me know.
Thank you, Your Honor, and thank you, Peter. No, I'll be there with bells on my toes, 8:30 on the 5th.
All right, I'm very prompt, so if you arrive at 8:30, we'll be ready to go on the record.
Thank you very much, Your Honor.
All right, so the matter is, both motions are taken under advisement. I will render a decision on February the 5th, 2026 at 8:30 a.m. via Zoom. And Mr. Page, if you'll renotice your motions for the date and time.
Yes, Your Honor. Is any further briefing required, or is that?
No, and it is via Zoom. I won't expect you to be in the courtroom.
Thank you, Your Honor.
All right, anything else?
Not for the plaintiffs, and again,
All right.
thank you for your indulgence, Your Honor.
You're
Peter.
welcome. Have a good